These are the statutory provisions of GRPs, Governor Reorganization Plans. They're found in Government Code Title II, Division 3, Part 2, Chapter 1, Article 7.5. That's a mouthful. There are provisions on what are called executive reorganizations. And Section 12080 of the Government Code defines the following terms. Agency, meaning all entities in the executive branch of state government, except for those administered by an elective officer. So those are the other 8 constitutional officers a GRP cannot affect. Lieutenant governor, treasurer, controller, superintendent, insurance commissioner, secretary of state, AG, etc. Next definition is reorganization, meaning the transfer of the whole or any part of an agency or the whole or any part of their functions to the jurisdiction and control of any other agency, or the abolition of all or any part of the functions of an agency, or the consolidation or coordination of the whole or any part of an agency or the whole or any part of their functions with the whole or any part of any other agency or functions, or the consolidation or coordination of any part of an agency or their functions with any other part of the same agency, or the authorization of a non-elective officer to delegate any of the non-elective officer's functions, or the abolition of the whole or any part of an agency, which agency or part does not have upon the taking effect of a reorganization plan will not have any functions, or the establishment of a new agency to perform the whole or any part of the functions of an existing agency or agencies. The next definition is resolution. And it's a resolution in either the Assembly or the Senate, and that either the Assembly or Senate does or does not favor the reorganization plan, number 1, for example, that was transmitted to the legislature by the governor on the specified date, and that it recommends that the plan be assigned to the appropriate standing committee of the Assembly and Senate. Next, there's Government Code Section 12080.1 that requires the governor to examine the reorganization of all agencies and determine what changes are necessary to accomplish one or more of the following specified purposes. The first one is to promote the better execution of the laws, the more effective management of the executive and administrative branch of the state government and of its agencies and functions, and the expeditious administration of the public's business. Next is to reduce expenditures and promote economy to the fullest extent practicable, consistent with the efficient operation of state government. Next is to increase the efficiency of the operation of state government to the fullest extent practicable. And then to group, consolidate, and coordinate agencies and functions as nearly as possible according to their major purposes. Next, to reduce the number of agencies by consolidating those having similar functions under a single head, and to abolish those agencies or functions as may not be necessary for the efficient operation of state government. And finally, to eliminate overlapping and duplication of effort. Government Code Section 12080.2 provides that whenever the governor finds that reorganization is in the public interest, that the governor is required to prepare one or more reorganization plans in the form and language of a bill as nearly as practicable, and transmit each of them bearing an identifying number to the legislature with a declaration with respect to each reorganization included in that plan. Additionally, the delivery to both houses may be at any time during a regular session of the legislature. The governor, in transmitting a reorg plan, is required to explain the advantages which it is probable will be brought about by the taking effect of the reorganization included in that GRP. And this plan must specify with each abolition of a function the statutory authority for the exercise of the function. And reorganization plans submitted to the legislature must express clearly and specifically the nature and purpose of the plan. Now, upon receipt of a reorg plan, the Rules Committee of the Senate and the Speaker of the Assembly are required to refer that plan to a standing committee of their respective houses for study and report. The report is required to be made at least 10 days prior to the end of the 60-day period for review by the legislature and may include the committee's recommendation with respect to a resolution. The resolution by floor motion may only be in order following a committee report or at any time during the last 10 days prior to the end of the 60-day period, and that resolution must be voted upon without referral to committee. Section 12080.3 specifies that each reorganization plan transmitted to the governor may change the name of an agency affected by a reorganization and the title of its head, and designate the name of an agency resulting from that reorganization. It may include provisions for the appointment of the head and one or more other officers of the agency whose appointment is subject to confirmation of the Senate. The term of office, if any is provided, must be fixed at not more than 4 years, and the legislature sets the compensation of department heads and officers. It shall also provide for the transfer of employees serving in the state civil service who are engaged in the performance of a function transferred to that other agency. It also shall provide for the transfer or other disposition of the personnel records and property affected by the reorganization, and it shall provide for the transfer of unexpended balances of appropriations and of other funds that are available for use in connection with any function or agency affected by that reorganization. It also has to provide for terminating the affairs of the abolished agency. And finally, it shall enumerate all acts of the legislature that will be suspended if the reorganization plan becomes effective. And then in Government Code Section 12080.4, it prohibits any reorganization plan from providing for or having the effect of continuing an agency beyond the period authorized by law for its existence, for continuing any function beyond the period authorized by law for its exercise, authorizing any agency to exercise any function which is not expressly authorized by law to be exercised by an agency in the executive branch, increasing the term of any office beyond that provided by law for the office, or by abolishing any agency created by the California Constitution. Section 12080.5 provides that the reorganization plan submitted becomes effective the first day after 60 calendar days of continuous session of the legislature after the date on which the plan is transmitted to each house, or a later date may be provided by the plan unless prior to the end of that 60 calendar day period, either house of the legislature adopts by a majority vote a resolution rejecting the GRP. Section 12080.6 prohibits any reorg plan from having the effect of limiting in any way the validity of any enacted statute or any regulation or other action made. Section 12080.7 prohibits the abatement of any lawsuit, action, or other proceeding lawfully commenced by or against the head of an agency or other officer of the state in their official capacity. Section 12080.8 specifies that from the effective date of a reorg plan, and as long as it's in effect, the operation of any prior act of the legislature inconsistent with the reorganization is suspended. Section 12080.9 requires each reorganization plan which takes effect to be printed in the same volume as the acts of the session of the legislature in which it was submitted. Section 12081 requires the Legislative Council to prepare for introduction not later than the next regular session, occurring more than 90 days after that in which a governor's reorganization plan takes effect, a bill that makes changes in the statutes as may be necessary to reflect the changes made by the reorganization plan itself.